Good morning, this is your Kelso Report for Tuesday, March 12th, and I'm your host, Clark Kelso. The Ninth Circuit gives us two search and seizure cases this morning, the first involving searches at the border, and the second involving searchers of probationers. We then have an interesting copyright infringement action involving the fair use doctrine, and we close with a state law decision about the value of a mechanic's lien. Let's begin with search and seizure. Almost 2 years ago, in the United States versus Cotterman, a split panel of the Ninth Circuit held that a search of a laptop computer that began at the border and ended 2 days later in a government forensic computer lab 170 miles away still fell within the scope of the border search doctrine. The Ninth Circuit took that case in bank and issued a new opinion last week. Although the majority still upheld the search, it was on a very different basis than the original panel decision. And the in-bank's rule introduces some new uncertainty into the legality of border searches. In this case, federal agents had seized the defendant's laptop at the U.S.-Mexico border in response to an alert based in part on a 15-year-old conviction for child molestation. The initial search at the border turned up no incriminating material. But after the laptop was shipped to a lab almost 170 miles away and subjected to a comprehensive forensic exam, images of child pornography were discovered. Although the in-bank majority held that the narrow border exception to a warrant requirement did not apply, and that the search was not an extended border search, because the search of the laptop was so comprehensive and intrusive, reasonable suspicion was required for the forensic examination of the laptop. The in-bank majority also held that on the facts present, reasonable suspicion was satisfied. Apparently once a sex offender, always a sex offender. I think the Supreme Court may actually take this case, because it creates a new category for border searches that is inevitably going to complicate and interfere with the work of border enforcement agents trying to figure out when the reasonable suspicion standard applies and what does that really mean. Our second search and seizure case involves probationers. Now, the law is well settled that the Fourth Amendment does not prohibit a police officer from conducting a warrantless and suspicionless search of a parolee. So said the Supreme Court in Sampson versus California. But what about probationers? Does the rule in Sampson apply to them? Well, the answer is a clear sort of. In United States versus King, a split panel of the Ninth Circuit held that where a defendant has accepted a suspicionless search condition as part of the probation agreement, the defendant has an extremely small expectation of privacy. And on the facts present in King, a suspicionless search of the defendant's residence was permissible. The majority's holding maintains a slight possible difference between the Fourth Amendment rights of a parolee and the Fourth Amendment rights of a probationer, something that the Supreme Court itself has indicated may be possible. So we'll have to see in future cases how that difference may play itself out. Next copyright decision. The Copyright Act is designed to promote the arts and stimulate artistic creativity for the general public good by giving authors of creative works a limited monopoly over the expression of their works. Because excessive enforcement by overzealous authors can actually stamp out the very creativity that the Copyright Act was intended to promote, Congress codified the fair use defense. Now, according to that defense, the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. The statute also lists 4 fair use factors that guide courts in applying the doctrine, including the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the copying, and the effect of the use on the market for the copyrighted work. In Sofa Entertainment versus Dodger Productions, a stage play dramatization of rock group The Four Seasons employed a 7-second clip from an old Ed Sullivan show, where Ed Sullivan is seen introducing the Four Seasons for the first time. The clip was used in the play to emphasize an historic turning point in the growth of the Four Seasons as a nationally recognized rock group. The owner of the copyright in all of the Ed Sullivan shows filed suit against the producers of the play, alleging copyright infringement. The Ninth Circuit affirmed the district court's summary judgment entered in favor of the defendant, finding that the 7-second clip was clearly protected by the fair use doctrine. The most important part of the analysis was the conclusion that the clip's use was transformative in nature. The play was not just copying the clip and selling the clip for money. Instead, the use of the clip was deliberately intended to mark an important moment in the band's career, and that was a critical part of the play's narrative. And in this way, the play added something new to the original work, expressing a new meaning and message. Because the fair use was so clear to the court, the Ninth Circuit also affirmed an award of attorney's fees to the defendants, noting that when a fee award encourages a defendant to litigate a meritorious fair use claim against an unreasonable claim of infringement, the policies of the Copyright Act are served. Finally, we have a case involving mechanics' liens. Now, to help make sure that they get paid, contractors are given the protection of a statutory mechanics lien, which is impressed upon the property that was built or improved by the contractor's work. One of the key issues that arises if a contractor needs to foreclose on the lien is how much value the lien covers. In Appellate versus Webcor Construction, the Second District had the opportunity to interpret the applicable statute, Section 3123 of the Civil Code. Now, the language of the statute is perfectly clear, as the court indicated, but another appellate court seems to have confused matters with some careless dicta. The statute provides that, quote, "The liens provided for in this chapter shall be for the reasonable value of the services, equipment, or materials furnished, or for the price agreed upon by the claimant and the person with whom he or she contracted, whichever is less." Well, the trial court interpreted the second part of this statute as simply not applying when the contractor is attempting to enforce the lien against a property owner who was not a party to the contract. But that is clearly not what the statute says. It says the price agreed upon, quote, "by the claimant and the person with whom he or she contracted," close quote. Doesn't matter who the owner of the property is. Well, having corrected the trial court's error, the Second District granted the requested writ of mandate and sent the case back to the trial court for further proceedings. And that's it for today's Kelso Report. Have a great day in the law.